which depicted starting from Rig Veda and Debasree. Yeah, please come. Okay. So you learned about purposes of marriage? No? Okay. So yeah. So according to Rig Veda, okay, there are two purposes of mention as mentioned here. Okay. First is to make a man complete, and second is to procreate a son. Now there are other purposes of marriage also, because when you talk about the first conception, now again when you talk about the Dharma Shastras, I think you in your library the PV Kana Dharma Shastras is there. So there you can find these conceptions of and purpose of marriage also, because when you talk about the concept of yajna, okay, there if you I think in Ramayana also you can see that when a man, or for example in Rama is performing certain invocation for the fire, Sita is always needed, right? Or for example, as per the Hindu Shastric understanding is concerned, it is always the husband and the wife or the spouses who need to, do the religious ceremonies together with respect to yajna is concerned specifically. Okay, so that's how to make a man complete, and procreate is that is progeny. Now again, as per the Hindu Shastras is concerned or Hindu mythology is concerned, or you can say that traditional Hindu family system is concerned, it is always believed that it is only the son who can actually help in salvation of the father. Okay, or you can see it is included in the pious obligation. Okay, now in pious obligation it is always mentioned that the son has the responsibility, for example, to pay the debt of the father also. Okay, so it's always is to procreate a son and not a daughter. Okay. Now the other objectives of marriage is Dharma Sampatti. Now Dharma Sampatti is please come. Your class, this class starts at what time? 10. Okay. Okay. Now Dharma Sampatti refers to, you can say, the moral and the ethical principles, okay, that guide the conduct of a person in their life. That means the moral or ethical principles which a man needs to follow in their life, okay. And then praja, that is progeny. Progeny means again the children, and the sensual pleasure, that is rati. Okay, so these are the, you can say, the main purposes of marriage is concerned. Okay. Now marriage ceremonies. Now what marriage ceremonies is required with respect to the validity of the marriage, right? You learn about section 5 of the Marriage Act? Yes. Section 7? What is section 7 is all about? Ceremonies of marriage, right? And section 5 is conditions of valid marriage. So if I combine these two sections, because when any validity of question comes, okay, it's not only with respect to section 5 is concerned, but you have to look into section 7 also. Of course, except in situations when only there is registration of marriages under section 8. Okay. Now, for validity of a marriage, there are certain conditions which is given under the Hindu Marriage Act. For example, the rule of monogamy is there. Okay. Then monogamy, you people know, right? A person can marry a single person only. Yeah. Then the age of marriage, 18 and 21 for the boys and the girls. Consent is required, valid consent. Then they should not fall under the degrees of prohibited relationship and subindulgence relationship. Right? Now section 7, the bare text, if you read from the Hindu Marriage Act, it mentions that the ceremonies of either of the parties need to be solemnized. Right? Now that means either of the ceremonies of the parties, that is the would-be bride and the bridegroom, needs to be performed for validity of the marriage. Thank you. So here, first of all, invocation before the sacred fire and Saptapadi is required as per section 5 and section 7. Okay. And yeah, there are certain cases which respect to that. If you just yeah, the first case which I mentioned here is Debasree versus Chidambaram. Now the court in this case views that to constitute a valid marriage, okay, two essentials need to be fulfilled, that is religious and secular. Okay. Now religious and secular element need to be performed for solemnization of the marriage, which is mentioned in Debnath's case. Okay. The another case which respect to you can cite in concept of marriage or the purposes of marriage is the second case, that is Bhaurav Shankar in the state of Maharashtra. Okay. Now this is also important case as it postulates performance of certain religious customary rites and religious ceremonies of either party thereto. And this case specifically emphasized on the concept of Kanyadan, okay, with respect to completion of the marriage ceremonies is concerned. Okay. Yeah. Now in India, what are the laws with respect to marriage is concerned? That is the legislature I am talking about, okay, because I have not included Muslim law here, you can see that, right? So Muslim law is of course governed by the personal law, that is you can say Quran, okay. So I didn't mention here as a legislature because Muslim law do not have a specific legislature which cite the conditions of marriage, right? So that's why I already mentioned Hindu Marriage Act, because it's only described the marriage. In Hama it's not there, right? And that is Hindu Adoptions and Maintenance Act, Parsi Marriage and Divorce Act, that is applicable to Parsis, and of course Christian Marriage Act, that is applicable to Christians. Okay, there, right? Okay. So you can just write that under section 3 of the Parsi actually it talks about the requisition for validity of the Parsi marriages. Okay, section 3. And Christian Marriage Act you can see from section 4 and section 5, okay, which mentions about marriages to be solemnized according to this particular act, that is Indian Christian Marriage Act 1872, and section 5 talk about persons by whom marriage may be solemnized. Okay, so you can read these sections from this particular legislature is concerned. Okay. Now coming to the emerging concept as I mentioned. Okay, what is the closing time of this class? 11. Okay, I don't have much time. Okay. So, okay. What is live-in relationship? Anyone? In live-in relationship there is no need of heterosexuality. Okay, yeah.
Two individuals living together without performing ceremonial rites.
Okay, if I ask that rights and responsibilities, okay, it's go hand in hand. You have jurisprudence?
No.
Not yet. Okay, there is a theory of Hoffman theory of jural relations and jural correlations. So there you can find that when you talk about right, it always comes with responsibility. Okay, so it's there. I think in your next semester or coming semester you will read regarding the concept of jurisprudence. So it's there. Okay. So in live-in relationship, of course, it works as a de facto marriage. Now, what is de facto marriage is? It's specifically, defined with respect to the conception that where a couple lives together and shares their domestic life similar to the husband and wife, but without any formal or legal marriage ceremonies, which I think you correct correctly, right? So that means in live-in relationship there is a consensual union or consent between the two parties that they will reside together. Okay. Now there is two things which you need to understand in live-in relationship. That is the concept of the concept of choice and concept of circumstances. Okay. There will be two-way go when you talk about live-in relationship. Now, concept of choice when I talk about with respect to live-in relationship is concerned, that is by choice, okay, the two persons are residing together. And for example, when you talk about the circumstances, okay, now suppose what circumstances can, plays an important role to have the relationship is, Suppose now there is a boy and a girl, okay, who reside, for example, they are in, for example, Bangalore, okay, they are job holders in IT sector, suppose. Now there you can see that there is a huge difference when you talk about the house rent, okay, or the other expenses is concerned, okay. Now suppose these two people, rent a single house or 1 BHK house, okay, or 2 BHK house to reside over there. So with time, through the circumstances is concerned, it may happen that if two individuals fall in love and of course they started actually residing together. Okay. Now residing together again, it's not only sharing the household is concerned. Okay. And it means with respect to live-in relationship or the marriage is concerned, the main ingredient is of course the cohabitation and to reside together and have the rights and responsibilities together when you talk about marriage. But live-in relationship, as it correctly mentions, that it do not have any legal responsibilities attached with it. It's only the rights of both the spouses, but there is a exception. Now when you talk about, there are many cases on live-in relationship. Do you have a legislature with respect to live-in relationship in India?
No.
No. Then it will be correct to say that live-in partners do not have any responsibilities or they can escape everything and each and everything? No. Then how the judiciary interpreted that concept of live-in relationship and included in the Indian legislature, okay, and give justice to the live-in partners. You read about some of the cases of live-in relationship. Any case law you know?
The second one, Debnath Sharma.
Second one you know. Okay. What has happened in place?
Debnath Sharma was in relationship with the VKV Sharma for
Yes.
8 years.
Right.
And he started business initially under her name, and then later on he started ignoring her, transferring all the business and everything to his elder son.
Okay.
Then she later on filed a case regarding the same, and in the case the court held that marriage itself, like she herself known from the very beginning that he is a married person.
Right.
So the consent was already, like basic understanding was already there to her mind.
Right.
And they said like basic marriage is a basic civil right.
Correct. Okay. So yeah, that is a very Indira Sharma is concerned. But in Indira Sharma, why this case is much important is that the Supreme Court in this case provides certain guidelines with respect to live-in partners are concerned. Okay. Now what are specifically those guidelines are? For example, first the Supreme Court mentions that there should be cohabitation between the parties. Okay. They need to share the social representation and of course they need to have the legal capacity to form a marriage-like institution. Okay. There are many guidelines on basically the common law marriage concept was actually included under this conception of Indira Sharma's case. Now there are many other contemporary cases also which I will discuss in today's class itself, that how live-in relationship is included under the legislature. Now you read about Protection of Women from Domestic Violence Act, DV Act, yet to. Okay, there is a, please can you just open Domestic Violence Act that I need you to read the bare text of law. Please open Domestic Violence Act 2005. Section 2 clause F. Can anyone please read that for me? Section 2 clause F of the Domestic Violence Act.
Domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or to a relationship in nature of marriage, adoption, or a family.
What is the time period to be included as in the nature of marriage, and what are the essential components which needs to be fulfilled to fall under that definition of in the nature of marriage? See, there are a subject in law that is interpretation of statutes. Okay, it specifically mentions the rules of interpretation, that how judiciary can interpret a particular section is concerned. Now, the first and foremost rule is with respect to literal interpretation of statutes. Now, that means whatever the black letters of laws are, the courts need to interpret. The courts need to apply the law as it is. Okay. Now, again in jurisprudence, in analytical school, what law is mentioned. Okay, and even various schools of jurisprudence mentions regarding what law is. Okay, but when you talk about specifically that what law is, that is the legislature makes the law. And the first and foremost duty of the legislature is to interpret the law with respect to the literal rule is concerned, because that is the intention of the legislature, that in what situation what laws need to be included, right? But when you talk about certain circumstances which is actually not, there is no law specifically with respect to that particular situation, then how the court can come up and give the decision. Okay, so there is two other rules of interpretation, that is one is purposive rule of interpretation and third is mischief rule of interpretation. Mischief rule, okay. Now, purposive rule of interpretation helps the judiciary to understand the purpose of a particular enactment, of a particular section is concerned. See, when you talk about a total object, what is the object of in totality with respect to a particular act is concerned, okay, you can read that from the long title of the act. And in every act, there is a long title, if not the preamble. In Constitution, we have preamble, right? So if you open the Bare Act, under the short title, that is the short title is the name of the act. If you remember any of the Bare Act, section 1 always talk about short title and extent, right? Short title means the name of the act, and before after the name of the act, if you open again, there is a 2 to 3 lines of description, an act to provide, like that. So that is the objective. It is known as the long title. So from there you can gather the whole objectives of a particular act, and each section comprises again certain objectives, okay, which we can find in the legislative drafting. If you read the legislative drafting of a particular act is concerned, it's there why a particular section is drafted in certain manner. And there is a very important role with respect to punctuation is concerned with respect to that. When the legislature need to put comma, semicolon or colon, or full stop is concerned. So in this definition of domestic relationship, in the nature of marriage, the Supreme Court interpreted that it is not marriage what we call as a legal institution of marriage. Under Hindu Marriage Act, Regulations 5 and 7 is concerned, but it may be certain institution which resembles like a marriage, but there is no formal union or formal ceremonies or formal legal formalities is there with respect to that way when we can say that okay, this is marriage. So it interpreted in certain other way, that is common law marriage, and actually included the legal partners in this definition, okay, and then it provides certain rights and duties. I will give you certain example. For example, there is a parties, okay, A and B. A is the living partner male and B is the living partner female, okay. Now the man, the male partner is already married, suppose, okay. For example, his house is in Kolkata, he is married there, and then for job purpose he shifted to, for example, Delhi or any of the metropolitan cities per se. For example, Delhi, okay. There in his office he met another woman with whom he fell in love, and he didn't disclose that he is married, okay. Now after some days they actually started residing together in an apartment, for example more than 2 years, okay, or 3 years is concerned. Now after that living, lady, okay. Now there is, for example, okay, I will give you another two situations. One is they are not married, they are residing together, okay. and after 2 to 3 years, suppose that lady got to know that he is already married. Okay. Now what remedy she has in that circumstances, and of course if married she knows, then of course you can refer to Indira Sharma's case, of course. So let's not discuss Indira Sharma's case again, and you already know that. Okay. So the first situation, when that leave-in part, okay, up to that particular lady in his office, and there is again a formal ceremonies of marriage is concerned. Answer two questions here: the validity of the marriage, and second, what remedy that particular leave-in partner or the wedded wife is concerned, or can I say even the wife? Anyone first?
Void.
The marriage is not valid. It's void ab initio. Okay. Now the second remedy, because she don't know, right, that live-in male partner is already married. What remedy she has, or is there any remedy? Anyone? No? She don't have any remedy? Or she has?
She has.
See, in law we have a maxim. No one can, take advantage of his or her own wrong. I think in CLAT only that is there. Right? This is there. In law, when you talk about, you cannot take advantage of your own wrong. For example, in this situation where the women do not even know that the person is already married, she trusts that person and married to that person, and after 2 to 3 years she got to know that he has already married. Okay. Now of course the Supreme Court in such situations mentioned that she has remedy with respect to that. But this again we can discuss with respect to the conception of the term wife is concerned. Okay, that what exactly known as the wife? Who is a wife? Okay, or for example for living partners, who are those partners whom we can include it in the nature of marriage under the DD Act? Okay, so that explanation you can find now 144(1) explanation of Bharatiya Nagarik Suraksha Sanhita, that is BNSS, which replaced CRPC. Right? Now there in the earlier in CRPC is 125 clause 1 explanation. Now it's 144 clause 1 explanation is concerned, where the term wife is statutorily defined. Can anyone please open BNSS 144 explanation clause? Please read that. It's a 2-line definition. 144 clause 1 explanation. In explanation, the term wife is defined. Please read that.
A woman who has been divorced by
Bas. Who has been divorced by? What does it mean? Divorce कब हो सकता है? When she is already married and validly married. Else divorce cannot be granted, right? There need to be a valid marriage to have a valid divorce also, right? To divorce by, that means a legally wedded wife who is divorced by, right? Okay. Second part.
or has obtained a divorce from her husband and has not been married.
Okay. Obtain a divorce from her husband, that is of course divorce हो गया है, the court granted the divorce and has not remarried. That means she is a, in general layman language, if I say she is a divorcee and she didn't remarry again, she is not remarried yet. Okay, so that is the definition of wife. Statutorily, if I interpret it by application of the literal rule of interpretation, that is what the black letters of law is done. Right? That is the legislative intention. Okay? Now, there is certain cases with respect to that. The first and second case, that is Yamuna Bai versus Anand Rao and Savita Ben Somamani Bhatia. In these two cases, what the court did is, it interpreted the term wife in a narrower conception and mentions that wife includes only a person, by applying this particular definition, only a legally wedded wife, and they do not have any remedy out of that marital institution. That means if there is a marriage solemnized between the two parties, okay, and the rule of monogamy is not followed there, the wife do not have any remedy, not including the concept of maintenance is concerned. Now we know that after marriage, what remedy the wife has? Matrimonial remedy I am talking about. In her matrimonial home, not from parental house, because then it includes the family law too, the property and the concept of co-custody is concerned.
Separation.
Separation, right, as a right.
Maintenance.
Divorce, okay, there are certain grounds of divorce. Apart from that,
Maintenance.
maintenance, okay. See, when the okay, now when there is a conception of a marriage, the only matrimonial relief the wife can sought until the husband is alive is maintenance in her matrimonial home, okay. And of course, after, if the husband died, then of course she becomes a class 1 years and have the property right from the joint family property. So that is another conception. So in these two cases, the narrower interpretation mentions by the judiciary and mentions that the wife do not have any remedies as such is concerned. Now the third case, that is which came in the year 2014, that is Badshah versus Sormila Badshah Godse. It took a broader interpretation of the term wife. Okay. Now, as I say, there are mainly three rules of interpretation. Literal rule, which is also stretched to the golden rule of interpretation. Purpose of interpretation and mischief rule of interpretation. See, there is a thin line difference when I talk about purposive and mischief rule. Although when you read the subject interpretation, it sometimes it will feel that okay, these two are same, but these two are not same. Is there a simple difference between when you talk about purposive interpretation, you may not need to see into the history or historical perspective to understand the perspective or the objective of a particular section or a particular act is concerned. But mischief rule, there are 5 ingredients which is given, okay, and while applying the mischief rule, the Supreme Court or any other court is concerned need to look into the historical perspective of a particular section or an act is concerned. So in this case, what the Supreme Court did is, it is not restricted, it didn't restrict the definition of wife with respect to only legally wedded wife. It broadened the conception of the term wife by applying the purposive rule of interpretation and give remedy to that particular live-in partners, or for example, remedy to that second wife is concerned. Okay, it mentions that what are the components needed or essentials needed to come in the, or to feel or to succeed while granting remedy from the court. Okay. Now there are certain. Now I will again ask one more question to you before I stop live-in relationship is concerned. It is For example, now there is a live-in partners. Okay, who is actually residing, for example, for suppose 15 days or 20 days together. Okay, and then suppose the live-in female partner asks maintenance from the court. Okay. First of all, the question may come that can it be termed as a live-in relationship from where she can, find maintenance as in, legally. Suppose they are residing for 10 days or 15 days is concerned. Okay. Can it come under, or more specifically if I say, under the in the nature of marriage definition given under the Domestic Violence Act? Because see, in none of the cases the Supreme Court defined the time period. It's open that how much time period is needed to grant any of the remedy as mentioned under the personal law is concerned in India. Okay, so there is a case with respect to that, that is Madan Mohan Singh versus Rajnikant. Okay, 10 SSC. Please note down the name of the case. It's Madan Mohan Singh versus Rajnikant. The citation is in bracket 2010, bracket close, then 9, volume is 9, SCC 209. Okay, it's Madan Mohan Singh versus Rajnikant in bracket 2010, after closing of the bracket 9, SCC 209. Please read that case. Here the court mentions that a man and woman resides together for a longer period of time than it could not be termed as a walk-in and walk-out relationship, and they will be presumed as husband and wife under section 119 of the BSA, that is Bharatiya Saksha Vibhadam, that is Evidence Act, which replaced the Evidence Act. That is 119, the presumption of husband and wife. So it's mentioned in this particular case, Madan Mohan versus Rajnikant, that if the parties are residing for a longer period of time, it cannot be termed as walk-in and walk-out relationship. Okay? And for example, by citing the Indira Sharma's case also, the essentials are given. For example, they represent in the society as a husband and wife. Or for example, they are residing in a society, suppose. Okay? For example, more than 5 years, 10 years they are residing. But there is no legal marriage. But the society, of course, when a man and a woman, for example, residing in a particular society for more than like many years, then what will be the general perception by the society? That it is the husband and the wife. So general societal perception, then of course cohabitation, and of course if the children born out of legal relationship, please do understand the child is a legitimate one, and of course the child has a right of maintenance and certain amount of property right only from the parents, not Hindu joint family property. It's only the legal marriage and the children is born out of that, not from where anyone can claim the joint family property. Okay, yeah.
Ma'am, if A and B are in legal relationship from 25 years and they have a son P.
Okay.
So A is not separated from his wife, but A is separated from his wife but not divorced. So can B entitle maintenance from A?
That means if I'm, poses this correctly, A is already married with someone, but there is no divorce, but he is residing separate with another woman. Is there any marriage?
No, ma'am.
Okay, living relationship
for 25 years.
For more, 25 years, and they had a son also, P. Okay, now your question is?
My question is B is entitled.
That is living partner.
Yeah.
Okay.
Is B entitled to maintenance from A and their son P have right in the inherent property of A?
See, to answer your first question, this is by applying the Madan Mohan's case. The wife, that is not the wife, the living partner B, she will get maintenance for sure. And
But
B
B cannot get it. The A is already married and he is not.
No. By applying these cases, Indira Sharma's case and then Madan Mohan's case, then VK, that is not this case. Then this Debasree Swami's case. These are Supreme Court cases and are binding under Article 141 of the Constitution, right? So by applying this case, the living female partner will get maintenance, and the children will also be legitimate under section 16 of the Hindu Marriage Act as amended. Okay, because now there is no conception as an illegitimate child. All the children born out of legal marriage or live-in partners
But both the parties, the maintenance is only available if both the parties are legally capable of marrying each other and if they are married. But A is
No,
not
let me
capable.
answer your first question. Okay, I will answer all your questions, but let me go by one. Maintenance, of course, she will get. The children also get in that period. But what is the children will not get is the inheritance right from the joint Hindu family property. Okay, the children might get the property only with respect to his parents is concerned. That is the live-in partners. Okay. Now coming to the second question, that is the that he is separated but not divorcee. In that case, this circumstances will be termed only as a live-in relationship. There is a US case, I forgot specifically the name of the case. This is based on same fact actually.
Kinley sir, who teaches us family law,
Okay.
he once said that legitimacy of children from the long-term live-in relationship. But inheritance in the inheritance property, they might be limited if relationship is not deemed married under the statutory law.
Yeah, of course, that is what I'm
So
saying.
no one
It
will
is
say
limited.
that we will get that inherit property, but he said because
See,
he is not the
inheritance
legitimate
property
child of
only
the.
get from the parents. Okay, not the joint family property.
Ma'am, my question was for inherit.
No. He will not get. That is what I am saying. No? From joint Hindu family property, he will not inherit because he is not born out of a legally wedded union, right? But the Supreme Court protected till the right which his parents are acquiring, self-acquired property. See, property you will divide in many categories. One is self-acquired property means the property which you acquire from your own income. Okay, and joint into family means the property which you inherit as a legal heir of your parents. For example, your grandfather has certain property. Your father, for example, is one brother or five brother, or you have sisters buas also, aunties also. Okay, that property which will be divided as a co-personal or as a legal heir as per Hindu Succession Act. That property will be distributed only with the co-personal is concerned or the legal heir is concerned. And now after the 2005 Amendment Act, even the daughter is included as a co-personal in the family. So that property will be inherited only with respect to class 1, class 2, class 3 years.
So if
But
C
legal
will
part
ask
of
for
no.
maintenance, she will get but not D. His wife will get maintenance but not C, the living partner.
Wife means the first wife.
Yeah.
Yeah, she can of course get maintenance
Inheritance.
and inheritance of the property also, but only if the husband died. Property right only comes to the legally wedded wife when the husband died. She becomes widow is a class 1 year. Okay, but until the husband is alive, she can only claim maintenance. She can claim divorce, applying the section 13 of the Hindu Marriage Act, or that is a ground also, if I interpret it purposely, section 18 of the Hindu Adoptions and Maintenance Act, there is a ground of wife when she can reside separately from her husband and claim maintenance. One of the grounds is desertion. The husband deserted the wife and reside somewhere else. So that becomes a legal ground for her. Another remedy she can sought is judicial separation, section 10 of the section 10 of the Hindu Marriage Act. Right, so these are the grounds where she can claim remedy. Property until the husband is alive. Any more questions?
Ma'am, in that property rights question, what if the A got
A means the husband. Okay.
husband got property inherently.
Okay.
Then he started
that is partition done.
Partition done. Then
Okay.
he started a business with that
From that
money.
property?
Yeah, from that property's money. So then will P be
No.
getting right to?
He says Tamil Nadu is very interesting. Even for example, from that property, he for example now in the contemporary era, for example the partition done for 30 years earlier suppose. In contemporary era, he for example have a business of 2 crore rupees suppose. Okay. Now his brothers are claiming over that property or that business is concerned. Okay, because it's but in that case partition should not be there. If partition there, his brothers cannot claim because property is separate. But in that case, if for example partition is not there, for example there are 5 brothers in a family. By using the family property, one of the brother is doing business. He went to the city, he started business from that joint family property. Okay. Then after 20 years, 50 years, 100 years, if the partition is not there, the brothers can claim over the contemporary property also. Okay, because he started that from the joint Hindu family property.
Yeah.
The money comes from that joint pool. Okay, so that's why you have to be very cautious when you are using the joint family property, because if you don't know the law, you may face these kinds of challenges.
Okay.
But once partition is done, this property belongs to you, and of course this is a self-acquired property. In that case, even if you do not want to give to your legal heir, आपके बच्चे, you can दान कर दो. क्या फर्क पड़ रहा है? No one can claim that because it's a self-acquired property of yours. I can do whatever I want to. For example, बच्चों से नहीं पढ़ रही है. There are many cases from Kerala High Court. जो प्रॉपर्टी लेने के बाद निकाल देते हैं घर से या फिर they misbehave. In that circumstances, if you have a self-acquired property, do not give them, make it and give someone else. No one can restrain you. Only the legal right with respect to children is concerned is from the joint family property and not your self-acquired property. Right?
Also,
Clear?
ma'am,
Yeah.
in marriages we are just talking about two Hindus in a living relation. Sorry. in
Yeah,
living
because I
relationship.
have straight out and I can teach Parsi and Muslim also.
No, also what if a man of Hindu religion and a woman of Christian religion, if they are
Okay,
in a living,
and again?
a man in a like Hindu religion
Okay.
and a woman in a Christian religion,
Okay.
they are living together. What
Huh?
about the remedies of a
Okay.
women there?
They married together.
Yeah, in special, like that comes under Special Marriage Act, right?
Indian succession.
Yeah, they are not in marriage, they are in living relationship.
Okay, in that case also, I don't think the court will discriminate on the basis of religion because Domestic Violence Act is a secular law. And the BNSS also, which irrespective of religion is applied. So the same remedy. Okay, हाँ, of course, अगर domestic violence एक religious centric होता, then maybe difference will be there. But then also BNSS is there, which is secular in nature. So remedy can anyhow govern it, right? Okay.
Very functional.
Okay. 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 I will take maybe 5 minutes of time. I will go first. Okay. Okay. Now concept of choice. What is it?
Senior or junior?
Concept of choice क्या है? When we talk about the matrimonial relationship is concerned, not to choose something to pursue. Okay. I'm talking about choice with respect to marital relationship. For example, everyone is adult here in this class, including myself, of course. Okay. Now, for example, someone is not married. Okay. She chooses to reside with a person who is also married, which is also adult. Okay. Now, can she do that?
Yes.
There is a Delhi High Court judgment recently. I don't know if you read about it or not. The man is married, okay, and had a girlfriend. The court mentions that it is permissible. Delhi High Court judgment. Which case is that? You which legal thing you follow? Life law, SSC or line or what? Life law. Is there life law? Please search this case. Okay. Okay. Now coming to this concept of choice. Okay. Okay. Now concept of choice legally under which section or which article we can include? Constitution. What is Article 21?
Right to life and personal liberty.
Right to life and personal liberty. It is one of the smallest article is concerned, but have many dimensions. One of the lengthiest, I can say. Okay, by interpreting that. So in this case, the concept of choice actually included under Article 21 of the Constitution of India. Who are they actually? They are from this class. So tell them to come here. Why they are doing this? They can come, it's okay. I was like, who is okay. So this conception, okay, recently in March 2008, that's the last case, Shakti Vaini versus Women of India. But before that, there are two most important cases again. That is Lata Singh versus State of Uttar Pradesh, where the court mentions that, or I can say affirm that, individuals of legal age have the right to marry whom they choose regardless of their caste, creed, religion, reinforcing the personal autonomy of marital choice. That is the, you can say, first case, which is, the most significant case with respect to the concept of choice is concerned. Okay, where the court mentions that yes, the parties have the right, okay, to choose someone, okay, and to reside with that person. Then second is of course Nand Kumar versus State of Kerala, which again came in 2008. In this case also, the Justice A.K. Sikri and Justice Ashok Bhushan mentioned the concept of choice as a fundamental right under Article 19 of the Constitution of India. Now, in this case, what happened is the girl attained the age of 18, that is the marriageable age under Hindu marriage act, right? But the boy did not attain the marriageable age of 21. So that is actually a dilemma for the court. Now, what to do in this particular case, right? Now, in this case, the court mentions that in this case, the court specifically actually again mentions about the concept of legal relationship of the partners, and even the parties did not complete the competent age for entering into a wedlock. Okay, they have a right to live together even outside the wedlock. That is the decision given in the Nanda Kumar case. Okay, and of course Shakti Vaina, I think everyone knows that Shakti Vaina is a very important case when you talk about the right to choose a life partner is concerned. It is a very recent case where the Supreme Court ruling that addresses the honor killing and affirms the fundamental right to choose one's life partner without fear of retribution is concerned. Okay, so these are the concept of choice is concerned. Please read these three cases. It grants man and woman the right to marry and found a family without any limitation due to race, nationality or religion. There are three articles in section, article 16 is concerned, section clause 1, 2 and 3, okay, which permitted to the right to form a family, okay. So that is a marriage institution, and ICCPR is concerned, that is article 23, there are 4 clauses, 1, 2, 3 and 4, which mentions about the protection of the family and the right to marry and found a family, okay. So if any questions in your examination is put with respect to right to choice is concerned, you can give these 3 cases, and of course these 2 articles which substitute your arguments with respect to right to choose one's life partner is concerned. Okay. Now any questions from today's class? Anything? Or no questions at all? No? Okay, then I will sum up the class.